Hello and welcome to Transforming Tomorrow from the Pentland Centre for Sustainability in Business. I'm Paul Turner.
And I'm Professor Jan Babington.
We all have the right to a healthy environment. But is this enshrined by international law? How can states regulate it? And how can courts actually enforce it? Jan, we had trouble with the law a couple of years ago and we've kept them off the show for a little while, but I feel the need to bring them back.
I think that's fair. Well, the law does insert itself in our lives in unusual kind of ways.
Yes, more often than we might like in some cases. Well, I'm talking about you, obviously, in that regard. In other cases, you might feel, where on earth is the law when I need it?
Yeah, but there's law and there's law. So we're going to do international law, which is the law that pertains between states. So that's a pretty interesting topic in itself.
Yeah, I'd really like to think you hadn't been involved with any international law, that you hadn't done something so grossly outrageous that countries, nation states themselves had to come forward and be involved in the case.
I plead the fifth.
We're not in America. There is no fifth to plead here.
In which case, carry on, Paul. Don't stop now.
Yeah, because when it comes to international regulations, international frameworks, international law, a lot of them might be considered around the climate.
Indeed, and there's been a small spate of really interesting advisory opinions related to climate change from a variety of sources. And these are, not laws that are being passed here and now that are going to apply to companies next year, but they are, if you like, the water within which we swim as to what the expectations are in around climate change and the duties of states, which of course then make their way through to duties on companies as well.
Yeah, and they might shape the future concrete laws that come into place, opinions now, rulings now, shape the laws of tomorrow.
So I only know one lawyer who's the very, very best person to tell us about that. Have we got him? Has he come on?
Well, unfortunately, the person who represented you in that case wasn't available. So therefore, I thought we'd bring back Camilo Cornejo Martinez, who joined us in the first series. And Camilo is a PhD researcher here at Lancaster University School of Law. He's looking at the evolution of international regulatory frameworks around just transition. So I think that he'll probably do the job.
He will indeed. He's my favourite international lawyer, without a doubt.
Welcome, Camilo.
Hi. Thank you very much for having me again. How much has changed the world in the last 2 years?
Yeah.
I think that was 2 years ago.
Yes, it was. Yeah. Lots of things changed. During the course of this podcast, I sometimes think that by the time we finished recording, the world's changed since when we started it. There's lots going on, but particularly in the legal world. And I know that there's been various different opinions and cases that have come about in the interim since we last spoke that are shaping how just transition, climate conflict is considered within law.
Yeah, it's hard to tell when these all changes start happening. But at this point, what we can say after the last 4 series of rulings is that definitely we are in a different momentum, we are in a different stage, and now the set of questions that we need to start answering are different.
And to get us going, so we're going to ask you first of all to explain sort of the context of 4 rulings, 2 which happened in 2024, 2 which happened in 2025, and then we'll go into depth in one of them. So these are from the European Court of Human Rights.
And would you like to say whose case that is, Jan? Because I know you've been looking forward to that particular part of this show.
Clima Signorinem. Yeah,
I'm pretty sure that's how I pronounced it before in my guess.
Yes.
Clima Signorinem
case, yes. Which is from Switzerland for European Court of Human Rights. There's then the advisory opinion on climate change from the International Tribunal for the Law of the Sea. Then there's an advisory opinion on climate change from the Inter-American Court of Human Rights. And the last one, which we will spend more depth and time on, and the most recent one in July 2025, the advisory opinion on climate change from the International Court of Justice. But I am just reading them out. The person who knows what that means is you, Camilo. So can you talk us through those 4 settings, and then we'll go into more depth?
Yeah, happy to talk about those cases. We can talk alive about them, actually. Like so many details, so many interesting stories. So for starting, like in a kind of chronological order, we start with Clima Signorinem versus Switzerland in the European Court of Human Rights. This case actually started in 2016 So another different world. In 2016, to have an idea, was the point when Paris Agreement was getting into force. A lot of things that we know now at that point were under serious questions. After this case started actually as a group of elder women, and they were asking to the government to be more ambitious on the climate goals that they were pursuing, because they felt that the actions that were taken were not enough for mitigating, and with no mitigations, the consequence and the effects of climate change, particularly in these vulnerable groups, could be massive in a couple of years. This case didn't have a great outcome in Switzerland, so that was when the decision to bring the case before the European Court of Human Rights was made, and that case was filed in 2020. The courts needed 4 years for giving the ruling in that case. Basically, the European Court of Human Rights said, definitely there is a connection between climate change and human rights. So climate change on one side can violate human rights. And this is particularly important in face of vulnerable communities as elder groups.
Just before we move on to the second case, Camilo, I just wonder, is it standard that it takes so long for a case to start out and work its way through the legal system before you get a final verdict from someone such as the European Court of Human Rights?
It really depends on the case, on the complexity of the case, on also the will of the parties. Some states try to question every single move of the other party, so it takes longer in those cases. But in the European and the Inter-American Court, used to be longer the cases. Tribunal of the Law of the Sea and the ICG took 2 years only, which is decent time from a legal perspective.
Well, let's move on to that second case then, the International Tribunal for the Laws of the Sea. ITLOS. Yes. So can you tell us a little bit about that one?
This case started in 2022, and the advisory opinion was released in May 2024. The difference with the European Court of Human Rights and Clima Seniorinium is that this case first is an advisory opinion. That means that there was no direct conflict between two different parties. Here, there was a group of islands that started with Vanuatu intervention that asked to the International Tribunal for the Law of the Sea to clarify how the convention should be interpreted under the new conditions of climate change. So the court, what is doing in this opportunity is just giving a kind of doctrinal interpretation, like a scholarly interpretation, on how we should start understanding and how we should interpret the convention in this new scenario. Probably the big outcomes of this case is that although the United Nations Convention for the Law of the Sea say no word about climate change, the tribunal said, well, in this context, climate change can be considered as a pollutant or pollution. And because of that, if we consider climate change as a pollution, then the convention is applicable to climate change. And states has the duty to prevent, control, and reduce greenhouse gas emissions as any other pollutant that might impact the seas.
That's quite an amazing one because that impact on the seas and that the jurisdiction of that tribunal is enormously relevant.
Yeah, and in this case, actually, the ITLOS advisory opinion might have an impact at least in face of 169 state parties. So, good number.
Yeah. So, the Inter-American Court of Human Rights, who is that and who do they cover then?
Yeah, well, this is another different tribunal. Just as a context, the international system has been developing since the Second World War in different branches or areas. So one side is human rights. And the idea that was put and was designed for the human rights context that might be better to make regional courts. So that is why we have the European Court of Human Rights, and we have the Inter-American Court of Human Rights, and we have the African Court of Human Rights. as a kind of pending project is what happened with Asia and that part of the world. In this case, what we are hearing in the opportunity is the Inter-American Court of Human Rights talking about climate change. And similarly to Clima Signorinum, here the focus is on human rights. This case started in 2023 when Chile and Colombia asked to the Inter-American Court to give the opinion about how human rights might be impacted and what states should do in considering the reality of climate change in the region. And the Inter-American Court of Human Rights released one of the most, to say in a way, progressive rulings at this time. The court take the opportunity for dealing with some of the topics and some of the issues that at this point none other tribunal has touched. For instance, the court directly talked about climate change, human rights, and the rights of defenders or those who aims to protect the environment and the climate. Or the court talks about the right of nature, and that is one of the favorite topics of the region. Or the court start talking about the right to a healthy environment for the region with very particular characteristics, like connected, for instance, with Escazú Agreement. And similarly, in this case to the ITLOS, this is an advisory opinion. Mm-hmm. This case was not a confrontation between two parties, was not a conflict between states in the Inter-American zone. This case started because Chile and Colombia have doubts on how we can apply the human rights framework to the climate change context.
It ties back into the discussions we had those 2 years ago about the rights of nature there as well. Yeah. And that's something then that was emerging. And to see that now is making its way into these advisory opinions.
And I didn't know what an advisory opinion was until you described it there. And that strikes me as a really wise way to start drawing out principles, not when you're in the midst of a fight, but actually to seek advice about what would be the right and the appropriate way to operate. So that seems like advisory opinions are really helpful then.
Yeah, and the importance of the advisory opinion in a first degree is for states that need to comply and need to meet the international standard. If a state doesn't follow those elements or those criteria, they risk to breach the international law, and that may imply a responsibility. So it's not like so soft, the consequence, but at the same time has another element that is relevant for other stakeholders, like companies, private actors, civil societies, NGOs, among others.
So how does the International Court of Justice fit within this framework?
Yeah, well, the International Court of Justice is, again, in this map of the international system, is for some of scholars called the World Court. This is recognized in the United Nations Charter and has jurisdiction over international matters in general. So the difference, for instance, with the Inter-American Court of Human Rights is that Inter-American Court is focused mainly on human rights. The ICJ, or the International Court of Justice, has a broader view of the international conflicts and also a difference with other regional courts like the European Court of Human Rights or the African Court of Human Rights. The ICJ has jurisdiction over all the state that has recognized and has not denounced the jurisdiction of the United Nations provisions.
Now, I think there's a key point you just made there. Those who
have not denounced.
Yes. So, therefore, who does have to abide by its rulings? Does anyone have to abide by its rulings, or can everyone just say, I don't like that particular ruling, I'm going to denounce you now?
Well, that is a controversial topic. And as legal scholarship, we don't have a definitive answer. On one side, there is a theory, there is a doctrine that said that human rights and the United Nations Charter aims a progressive realization. So that means that we cannot go backwards. We need to push and we need to move forward. If we denounce, we are in direct contradiction to that principle. So the discussion that is, well, what happened with the state sovereignty? States are sovereign and they should denounce, and they are not obligated to be in a treaty if they don't want to. So the clash between both principles is a discussion. But in general, some states, what used to do when they are not really happy with some ideas on a treaty is that they make some reservations. So, for instance, the kind of classical example in the ICG context is what happened with the US. The USA said, well, I'm really happy with the United Nations charters, wonderful, beautiful, but I'm not totally convinced with an idea of a world court making rulings that I should follow mandatory. So the US said, well, I'm part of the United Charter. I recognize in a way, in a degree, the court, but I'm not following their mandatory rulings because I am a sovereign state. And then we have the other case, more extreme, when we have this discussion on can one state or not denounce and not continue in the jurisdiction of the court.
So, bearing in mind that these findings and advisory opinions will have different elements to it, let's focus on the ICJ, the International Court of Justice. What's the essence of their opinion? What did they say?
Well, this is my reading of the advisory opinion, so I want to make this warning. Because at this point, one of the things that is happening is that different scholars and different readers are having different conclusions about the ICG opinion, advisory opinion, which is in a way quite good because we can keep the discussion and we can keep progressing on how we need to interpret climate change in the context of international law. So, in my view, there are three main elements of the ICG. First is about the history and evolution of the climate regime and the opportunities that this advisory opinion is unpacking and how climate regime is going to evolve from now then. As an example in this point is again connected with the origin of the case. The ICG case starts with a civil organization, a group of students from Pacific Islands. They organize and they say, well, it's not really fair that because of climate change, Pacific Islands are going to lose their territory and potentially the character of states. If you don't have territory, how you can be a state? So that was one of the questions. And this group of students start connecting, networking, pushing with this idea until we finish in this opinion before the advisory, as an advisory opinion before the International Court of Justice. So they achieve more than 150 states, I think, agreeing with the petition before the advisory opinion. Like United Nations unanimously agree and send the request to the court.
That's amazing.
Yeah.
But also should be inspirational. I know we have quite a lot of student listeners. A group of students can make the world change. If you ever needed evidence, here it is.
And the talk about these groups of nations coming together reminds me a lot of when we talk about the Global Plastics Treaty and the discussions that were going on and how you have interest groups involved there and different groups from like the South Pacific Island states, and you might have other island nations coming together because they're the ones, like you say, in terms of climate change, big risk, and as we discussed at the time, in terms of plastic pollution.
Brilliant.
It's a powerful message for civil organizations and for private actors. And I want to recall just a short phrase when we start talking about this topic in the podcast. We said, well, international law is related with the states. And I think that this is one of the points that the advisory opinion is breaking in a way, because this is showing that civil society, individuals have a clear space and have a clear role in the international law.
That's brilliant. So the first bit of their opinion was about the evolution of the climate regime. What are the other elements?
Yeah, well, the other elements is particularly on how the climate regime is articulated. We have in climate change law too many different institutions, treaties, COPs, that at some point is confusing, even for the most knowledgeable legal experts, on how all these elements play together. So the court take a couple of steps back and say, well, we have three main treaties or agreements. The first is the United Nations Framework Convention on Climate Change that was agreed in 1992. This is, to say in a way, the mother treaty. And the court said, well, this treaty is quite clear in what is the aim, what is the goal. And this treaty is not just a political view, it's not just any other political declaration. This treaty is mandatory and this treaty has obligations for states. Then the court said, alongside this main treaty, we have Kyoto Protocol. That for a long time we thought that Kyoto Protocol was dead, but actually not. And the court said two important things. Said Kyoto Protocol has a series of principles and in a way is making more concrete the goals that parties agree in 1992 in the Framework Convention. So Kyoto Protocol also has another clear idea on how states should reduce the emissions. And the court said this is important because this is a proof that for states is not also a political aspiration. States are obligated to reduce greenhouse gas emissions. And then we have Paris Agreement. And this is probably the most well-known climate treaty. It's quite relevant. And the court said that Paris Agreement is under the umbrella of the United Framework Convention on Climate Change. Articulating these three treaties, the court said that there are at least a series of obligations that that states should to follow, mainly in mitigation and adaptation. So in both realms, the court found that a state needs to meet certain requisites. That is in one side. But then the question was connected with the poll question a couple of seconds ago. What happened with those states that are denouncing, for instance, any treaty or Paris Agreement? So the court said, hold on, we also have something to say here. In international law, we have different sources of obligation. On one side is this group of treaties. But the court said, well, also we have customary international law. So if all the states are acting in some way because they consider that they are following the rule of law, that means that it's a general rule that every reasonable state should consider. So the court said, even if there is any state that is not part of these treaty regimes, there are two important obligations that are coming from the customary international law that states need to follow. The first is the obligation to prevent harm to the environment. And the court said states need to avoid any harm to the climate system. And then the court added another particular element saying that states, in order to meet that obligation, need to carry a due diligence process. So in a way, it's a compound duty that states have. They need to prevent, and in order to prevent, they need to apply a due diligence standard. And the other main obligation that the court found is that a state has a duty to cooperate. And the court said, don't look this duty to cooperate so light. It's not just we're friends and we're giving the hands and I'm supporting you. This duty to cooperate is a duty under international law and has different ramifications, different expressions, for instance, like technological transfer, finance, among other instruments. So that is in a way what the court is trying to articulate, how this treaty system works alongside this other set of obligations. And by the end, and that is one of the disruptions of this advisor opinion, we can read in the ruling that doesn't matter really if you haven't signed or not any treaty, or doesn't matter if you denounce the treaty, because in any case, you have the duty to protect the environment.
That seems like actually I'm quite excited. But was it Was this kind of opinion expected, or was it people like going, "Oh my goodness," or because there must be an array of response to it. So maybe starting with your own, what did you find this very exciting and unexpected?
No, but was very excited and very unexpected in different layers. At international level, tribunals used to be very conservative, to say in a way, because there is this idea of sovereignty, and the heavy of sovereignty always relevant. So for tribunals and for scholars for international law, it's not easy to say any state has this duty, doesn't matter if they have signed it or not the treaty, because what you are affecting is the sovereignty of the state. That is the very basic, is the grammar of the international law, is the grammar of the system that we are living together. So at some point, there were a group of scholars very pessimistic about the outcome of the ICJ. There were another group of scholars more optimistic, but I think that even the optimistic group was not thinking in this outcome. Oh. Particularly because another historical discussion is about the right to a healthy environment that is not expressly recognized in any treaty at international level, covering the whole world. And the court said that actually considering international domestic regulation, considering all the set of activities that the states are doing at international level at this point, it's not really hard to recognize that exists a right to a healthy environment. So,
what do you think then are going to be the effects of this ruling going forward?
Well, the court is quite clear saying that states need to regulate in their territory. And the court is quite clear also adding that states are responsible on what happened in their territory and also in the activities they have control. If they don't regulate, if they don't control the activities under their frontiers and the activities that they can control, they are breaching the international law. So what is expected now is that states start getting more ambitious on climate change, particularly on this goal of mitigation. The court reaffirmed that 1.5 degrees Celsius is the goal that states agree. So that is the standard that a state needs to meet. And additionally, I think that as we were talking, civil society and organizations find a place now in the international law, and they are going to use different instruments, different moments for using this ruling. So only one side, but just to prove the point, is climate litigation. After this, we are going to have a new and a different wave on climate litigation.
But what about those countries that are politically at the moment swinging in completely the opposite direction? What about the likes of the USA, where they've got a president at the minute who thinks that it's a load of hokum, climate change, etc. And in a country, especially where the Supreme Court is very political as well, so therefore the politics of the courts are very similar to the politics of the government.
Can we switch the question and applying for my visa waiver? No. No. Well, the ruling has also. I think that the judges were quite mindful about this point. They don't talk directly about the political change and the political cycles that different states might be suffering. But the court said that it's quite clear under the international law that if you have an obligation and you don't meet that obligation as any other obligation in law, you're going to suffer consequences.
And I suppose the consequence isn't theirs to put on those states, but it opens up the door for citizens and other groups to be able to pressure.
Yeah, and well, that is one of the potential that we've seen actually in the first period of Donald Trump, that when the state change its direction, the civil society organizations or different institutions start taking the lead. So it is expected that the U.S., although the government, the official answer is that they are not fully agree apparently with the climate goals. At internal level, in domestic level, organizations and other institutions are going to push, or at the state level, they are going to push for keeping the 1.5 degree goals and adaptation goals.
And I suppose from a business perspective, this, that you pointed out that it's a different regime for climate litigation. So that's obviously something that business will have to be thinking very carefully about. But then also there was a phrase you used that really caught my ears, and that said activities where they have control. So things like due diligence requirements on corporations which are headquartered in your state are then immediately activities where you do have control. So even while the EU is currently backsliding on due diligence in sort of quite a wholesale way, this in some ways actually helps staunch that backsliding, because there is actually a potential there for business regulation as well by the state.
And this is one of the points that I think that was carefully written by the judges on this advisory opinion, because they were clear that the responsibility of states is for their territory and the activities they have control in their territory. So they add that phrase not once and in different chapters of the ruling. So at this point, it's really difficult to think, well, if the state has no control, how can react? And the second consequence of this is regarding the climate litigation again. We've seen a couple of months ago this case from Germany where a farmer from Peru started a complaint against a bank in Germany for the climate hazards that his farm is suffering in Peru. One of the arguments of the case and one of the discussions that the scholars are having now is, well, why in Germany? And the answer is, well, because Germany has control over what finance system is promoting.
Mm-hmm. Yeah, that'll be tricky. It'll be interesting to see how that comes through, because that's actually quite a big stretch, isn't it?
Yeah.
Yeah.
Which I guess brings us to the what's next. It's the question, so just to wrap things up, where do you see this space moving now? Are there any legal cases that are currently ongoing that you're waiting for an opinion, a ruling on, that you think might shape this? Where's this area going to move to?
Just in a couple of weeks, we have seen the effects of the advisory opinion from the ICJ. So, for instance, at the moment, South Africa, Canada, and Brazil has quoted directly the ICJ opinion for solving cases. Even when the advisory opinion is a new ruling, we already seen this. The Council of Europe and South Korea are also arguing cases using the advisory opinion. So, as in this couple of months, we can see already that the advisory opinion is putting the direction on the question on how we can achieve the 1.5 degrees, how we can achieve the adaptation goals. So I think that the questions now are not anymore on how climate change is connected with human rights or what is the value of 1.5 degrees. The question now is how we can agree that. In that context, there are two main areas that we are aiming to see more developed. One is the idea of loss and damages, because the court also said a couple of ideas about that and how a state and who needs to respond for the damages that climate change is making. The other idea is how climate change is connected with other treaties and with other regimes. Human rights at this point is quite established, the link between climate change and the institutionality of human rights for protecting, for discussing climate change, for finding remedies on climate change. But the court also said, well, there are other areas. Look at what is happening in biodiversity. Mm-hmm. The court said there is a convention, and the Convention on Biodiversity is also protecting the climate system and protecting the integration of the climate system with other ecosystems or how the ecosystem works. the court also said pay attention or pay more attention to the law of the sea. So in these other areas, we think that the work now is how we can take the ideas from the advisory opinion to these very specific hot topics. I think that the next step might be trade law, finance, and finally, just to follow up with what is next or what we are expecting now, is the African Court of Human Rights. They should release their opinion on human rights and climate change. And in the scale also, the African court has so many particularities and has so many different ways of reading human rights and reading international law that will be very interesting to see how they see this connection.
Well, I certainly feel a lot more informed after this discussion, Camille. Thank you.
That's amazing. And because I see these things, and I'm sure many of our listeners too, go past us in the newspaper and we go, well, that sounds interesting. I don't know what it means. Whereas I now know what it means.
My only disappointment is that when he listed, this will have effect on trade and finance, he didn't then say on accountants. So
Well, let's leave that go by. He's trying to bait me. Just ignore him.
More accountants, more regulation. Camille, thank you very much for joining us once again.
Thank you very much for having me.
It always makes things complicated, Jan, when we bring the lawyers in.
It does, but I like the complications. And you also get a sense in which this changing international landscape, which will cascade through country level, but then also will cascade down to businesses wherever they are in the world as well. So it was complicated, but it was really helpful.
And it's fascinating to see already how there are some countries in the world who are using this judgment this advisory opinion, and that's the key aspect,
Yes.
from the International Court of Justice. And they're using it in rulings, judgments, advisory opinions in their own country. So you've got the likes of Brazil, South Africa, other nations doing it and demonstrating that, while what the ICJ have said isn't binding, it is very much influential.
Yeah. And there was a phrase that Camilo used that I really, really loved, and that is the grammar of international law. And that really helped me understand these different rulings, because I knew they kind of existed. They went past on my news feed like everyone else, and I didn't understand how they fitted together. And then really excited for him to let us know that there is going to be an advisory opinion coming from the African court as well. And it makes me feel like it's much less colonial than it might be, because what you have is different parts of the world seeking to understand and build off each other's understanding in ways that are suitable for their context.
Yeah, because you have the African Court, you have the European Court of Human Rights, you have the Inter-American Court of Human Rights, and then you've got the Pirate Court, or the International Tribunal for the Law of the Seas. Yeah, I like to think that really is just for Long John Silver and his ilk.
Hereafter I'm going to call it nothing but the Pirate Court. And that was obviously fascinating to me, because, dear listeners, you'll know that I hang around in ocean science and am very interested in fishy things. So actually to see that law of the sea really having a dedicated theme running through as well means that everyone who's operating in the ocean will actually be influenced by that as well. So you've got country as well as sector.
And it's really good to see the various events that we've talked about across the course of this podcast, the 1992 in Rio, the Kyoto and Paris, they have all influenced this. And while people might not necessarily have all signed up to it, while some of them may have denounced it, as the phrase was, they're still going to be affected by it when these other international laws come down, because they'll say, it doesn't matter if you signed up to Paris, it doesn't matter if you signed up to Kyoto, you still have to listen to this. This is still international law.
And I think that certainly gave me a lot of hope, because the world can be quite dark when we think about climate denial and changing policy landscapes, etc. But the podcast data tells me actually there's still a continuing dialogue and a process that will actually still address these things. So certainly I felt uplifted. But then I always enjoy seeing Camilo, and I always feel better after having seen him, which is a good outcome for any interaction.
Yes, he's not one of these visitors who are darkening your doorway.
Not at all. He lightens my doorway, which I love.
I'm glad to hear it. And something else that he brought up that was really positive for me was the fact that even when the political winds are blowing in a different direction when it comes to things such as climate change and sustainability, even when you've got governments in power who might not want to enact policy or just do things generally that are going to be positive with regards to these areas. You've got individuals and businesses who will pick up on these rulings and who will act upon them and do things that are based upon them. So therefore, there is positive action taking place, even if it's not always coming from central government.
Absolutely. And one of the key phrases were the connection with climate change and governing actions where they have control on behalf of nation states. And that includes corporate governance, critically. So I was very pleased about that as well.
So we're talking about people darkening your doorways. That really brings me to next week's guest, because sometimes we bring in notes from home. Next week you're bringing in your husband.
Yes, indeed. And it doesn't darken my doorway as much as enliven and lighten my life. So I don't know where the darken the doorway business
It's not
comes
what
from.
you say when we're not recording.
That's not true, dear listeners and dear husband. That's not true. Yeah. So why is Jason going to come?
Yes, Jason Harrison will be joining us, not to discuss life at home with Jam, but to discuss various aspects of mountains and eagles, because he's got expertise in history of the clearances and the effects on eagles in Scotland, and also of mountains and preserving mountains and how that fits in with sustainability.
And I can guarantee that's going to be interesting. Even on the nth time of hearing about it, I find it interesting. So, dear listeners, you're going to be fine.
A bit more enthusiasm and, honesty in that statement would have been good, Jan, but we'll let you away with it. Well, until then, thank you very much for listening. I'm Paul Turner.
And I'm Professor Jan Babbington.